I'm joined by the partner at Napthans, Andrew Holden, who is an experienced litigation solicitor. And Andrew has explored what happens with these agreements, and he's going to explain what happens in these instances and when these agreements are broken, and how a business can deal with this and potential impact on businesses. So, Andrew, can you explain what sort of restrictions are we talking about here?
Well, these are the standard restrictions that you'll see in most employment contracts. People are very familiar with them. You're talking about the restrictions on joining competing businesses, working in competition with your former business, and may also be poaching customers, poaching staff, taking entire teams away. Really, it's not so much the type of restrictions, but where they're being used and by whom. And the reason for this is in most standard employment contracts, these sort of restrictions are seen as being unlawful as a restraint of trade unless they protect a legitimate business interest. But where they are of more interest to practitioners and where they're more difficult for those who break them, is it really in the scenario of a business sale or a share sale or the exit of a very senior employee from a business? So, for example, someone who's started up a business may choose to sell it to a competitor or an investor, and they'll be exiting, and often they'll be exiting having received a very handsome amount of money, which could be millions, could be 10 millions. And the idea will be for them to exit the marketplace for a period of time, at least, or possibly even forever. They may be retiring. Other situations arise where you have senior employees who have some shares, for example, and these shares may themselves be very valuable. And during their exit, not only are they leaving their, saying goodbye to their employers through leaving their terms of their employment contract, but also they may have to sell their shares for a substantial consideration of tens of thousands, even hundreds of thousands of pounds. And then finally, the other main scenario that we're thinking about are senior employees who are leaving a business. And as part of that, there's a settlement agreement. And as part of the settlement agreement, they are promising to honour the restrictions in their employment contract. And in return for that, they'll be receiving a substantial sum of money, which will be tens of thousands of pounds. So you've got those are the kind of scenarios that really we're thinking about here.
So each business can tailor their restrictions accordingly to what's important to them, essentially.
Absolutely. You might not want a non-compete clause. You might just want a clause that prevents them from taking existing customers. But if somebody sold a business, you're probably going to be wanting for them to leave the market in its entirety. And really, we're thinking about the protections that exist for those circumstances.
So who typically breaks these type of clauses then, and
Well,
these restrictions?
what we're seeing at the moment in the team is we've had a number of these cases crop up over the last few months. Situations in which a professional in a senior position within a professional services firm has chosen to leave his company, has entered into a settlement agreement with quite a generous pair, many tens of thousands of pounds, and within no time is back in the market for working with a competitor. Similarly, I've seen a couple of times since Christmas situations in which a senior employee has left a business, and as part of his exit has signed off a shareholders agreement and sold his minority shareholding for well over 200,000, and has agreed in that agreement and in a settlement agreement that he would honour restrictions in the contract, such as non-compete, not poaching customers, not poaching staff, etc., only to within months take a very senior role with a competitor. And we also, more occasionally, but we have seen in recent years, situations where a business has been sold and restrictions in the sale contract preventing the sellers from working in the market for a period of time, for those sellers to essentially start a new business, which it is felt by the business that they've sold is in competition with their own. So those are the types of people who are then finding themselves in dispute effectively with the buyers of the business or the business itself that they have left. And that can cause some significant friction.
So when the senior employees or former employers have broken the restrictions, it can, whilst it's benefiting them, it can impact the business. How else can it impact the businesses as well?
I think from the former businesses' perspective, the question really arises as to what harm can be done with this person or with these people still in the marketplace. And I think that often depends on their sophistication within that marketplace, if they know it well, if they've been leaders in the field. You might find the new entity has the ability to offer the same products, same good services. You might find that they're able to attract their old customer base. You may find they're able to attract their old staff. And in some circumstances, that can really diminish the value of the business that they sold, and it can even pose an existential threat to that business. So in that situation, the sellers have left for many millions of pounds. They don't have to work again. They've been handsomely rewarded as part of the sale, but then they come back into the market potentially, and that can cause real problems for the sellers. In other situations, the question really becomes how much of a threat is that senior person to your ongoing customer base staying with you, or your ongoing your teams staying with you, and you have to look at that on an individual by individual basis. You may find they don't pose too much of a threat, and you may be willing to reach a compromise. On other occasions, you may be quite sore. If somebody has signed off a settlement agreement or has sold their shares in the business back to you as part of their exit and said, of course I'm not going to compete with you, of course I'm not going to pinch your staff, of course I'm not going to pinch your customers. And then lo and behold, they're doing just that. They've popped up at the other side of the square, for example, at your main rivals, and you've just given them a significant sum of money, you're going to be pretty sore about that. And often you will have a clawback within the contract that means that even if actually they're not that big a threat, the fact that they've rather played fast and loose with their contractual promises, that allows you to bring a claim for the return of that money. So sometimes it can be an existential threat or very serious in terms of lost revenue, to being possibly little more than the embarrassment that you shook hands, said goodbye to someone, gave them several tens of thousands of pounds you may not have needed to as a gesture of goodwill and a thank you
But
for their service,
but it could also impact future clients and customers as well for
Well,
the business.
it can if the intention was somebody's going to move out the market completely, and lo and behold, they're back in it shortly after selling the firm with a new venture. Yes, it could. I think that's less likely with a situation where there hasn't been a business sale.
Okay, so in terms of these breaches, how should a business deal with these breaches?
Well, I think you're really looking at assessing what the impact's going to be first and foremost. Um, if it is the case that somebody has promised not to compete, not to take on work from their former customers, and is doing so and is getting traction, then you're probably looking at a situation where you want to nip that in the bud, and that can be done relatively quickly, and there's an established mechanism for doing so through injunctive relief. And in the circumstances in which a business has been sold or shares have been sold, as well as senior people leaving the business, you've got that commercial deal. It's not just an employment contract, but a commercial deal. Then the courts are not going to look too closely as to whether these restrictions are or are not unreasonable. Their focus really is going to be to look at the dealers around and say, well, has that person been compensated for exiting the market for a period of time? Was that part of the price of the sale of these shares or this business? And in many share sale situations, the answer to that would be yes. And so relatively easily, you should be able to obtain injunctive relief. It becomes more difficult in the situation of somebody who's just an employee, albeit a very senior one. But you would still wish to assess the severity. You can protect yourself through injunctive relief. You can also, as a first step, get promises from the person in breach to stop the breach, put a stop on the breach, exit the market, and then assess, what have you actually lost? Are you losing money? Is there a damages claim? And going back to my point earlier about settlement agreements, settlement sums being paid in settlement agreements in return for the promise to honour restrictions in an employment contract, you may find that you've got a relatively straightforward way of reclaiming that sum. So a fairly easy win on a claim of a few tens of thousands of pounds.
So how can a business discover that a breach is happening or it's occurred? Because I know sometimes these breaches can happen prior to the contract being signed, and
Yeah,
it's in different stages.
I think. Well, I mean, it depends very much on who's doing what. Some people may be planning all along to pull a fast one, and if that's the case, you may find that they've left a bit of a digital footprint. They may have downloaded information they shouldn't have been downloading from the business, trade secrets, confidential information, and being foolish enough to actually send that to their private email address, or they've put a pen drive in the computer and downloaded the data there. And we do see people being that foolish, for want of a better word, about it, because you do leave a footprint. In other circumstances, um, there may be no real intention prior to leaving the business, but what you might find is they pop up at a competitor and it's all over LinkedIn or other social media. And that does happen. Clients do contact us from time to time to say, hey, X has left, and now he's working for one of our main competitors, and we're not very happy about this because he said he wouldn't do that, and he was paid quite a generous amount of money when we said goodbye to him. So social media can often be the play. Other circumstances, trade fairs and networking events within a sector, that happens. It's not unusual at all for these types of disputes to start when somebody gets tipped off that a customer has seen or been approached by a seller of a business or a senior executive who's left an organisation and now is back in the sector in a new venture. That's not unusual at all. And similarly, you might even bump into them yourselves. And even on occasions, there might be a difference of opinion as to what amounts to competition, to the extent that that individual who set up a new venture may contact you himself and say, oh, can we work together on this, that, and the other? And the business might go, hold on a minute. We think what you're doing actually is not particularly complementary to us, but it's in competition, and we're a little uncomfortable about what you're doing, and we think you might be in breach of some of your restrictive covenants. So there's a whole manner of ways, but I suppose in the worst case scenarios, it's when you start to see customers or staff leaving to join a venture that you thought didn't exist, or a venture that competitor that you know exists, but the connection is that individual who's left, who may have been the seller of the business to the new buyer, or a senior exec who's been with you 4 years, and he's just, having left, decided to join your main competitor.
So, in terms of tips, what practical tips would you give in these situations?
Well, I think practically, the first thing to do is probably to try and understand what the risk is to you. How serious is it? Is it an existential threat? Are you at risk of losing very significant amounts of turnover? Because if it is, then you're going to want to move towards injunctive relief pretty swiftly. If it's not so serious, then there's a cost-benefit analysis to be done. Usually, you could nudge somebody into a position where they may be persuaded to honour the restrictions or honour some of them. Similarly, you may find, especially if there's a clawback of payments of money if they are breached, that you don't really need to provider. You don't really need to go and get an injunction if they're not a particular threat, but you've got this right in contract to take back a settlement sum that you paid to the former employee on their exit, and there's no reason why you shouldn't put a claim to such an individual and say, look, we want this cash back. It is, after all, a contractual right that the business has. I mean, once you've got that strategy, or what your objective is going to be in your mind, you can start to do more practical things like, well, what's the evidence? What evidence have we got? How do we capture it? You know, if he's popped up on LinkedIn or in social media, screenshots, if he's been seen at trade fairs, networking events, well, who saw them? Can you get a witness statement? If it's your staff, almost certainly. If it's customers, suppliers, are they prepared to give that evidence? And do they have is the documentary evidence from them, or the email and say, look, this is what we found, this is who we've seen, and will they stand by it? And then obviously there's the internal information. What digital footprint have they left? I mean, that's especially important if they've been taking a lot of confidential information, which often happens in these situations. So when these cases become litigious, there's often not only the threat of breach of contract because of the breach of the restrictions, but it's often accompanied by a claim for breach of confidentiality.
Thank you, Andrew, for joining me to look at post-termination restrictions in the commercial settings.
No problem. Thank you for having me.
If you would like to find out more details as to what NAPFINs can do and to provide support, please visit our website. And thank you for listening and watching our podcast.